Unfolding at the Constitutional Court at this hour, of course, Solidarity and others are challenging parts of the National Health Act. In fact, it seems the justices have taken their seats. Let's listen in.
Gracious Tefu and Patricia Mpela have taken care of my mother at her home. I procure their services through a health agency as defined in Section 1 of the National Health Act. That is, a business supplying healthcare personnel to users. Dr. Elise van Heerden is a general practitioner in Bloemfontein. She's been a doctor for 30 years. Her doctor's rooms are part of her home converted for the purpose. She is a healthcare practitioner as defined, and the converted portion of her home is a health establishment as defined, a facility, building or place where for profit she offers diagnostic or therapeutic interventions and other health services. Johan Kok and Cholwe Nukeri are fourth-year medical students at the University of Cape Town. After obtaining their degrees, they will complete their internship and the community service, and after close to 10 years of study and working in public institutions, they may wish to enter private practice. They stand shoulder to shoulder with the 4th to 7th applicants in this matter. Amongst them, Barbara Pretorius, whose affidavit is at page 137 of the record. She describes how since the early 2000s, she has developed a physiotherapy practice in Knysna through the investment of resources and costly equipment. She's involved in her community and she maintains close relationships with her regular patients. Dr. Brian Spiss, whose affidavit appears at page 148 of the record, moved to Menlo Park in Pretoria in 1990. He has operated his private practice out of his home for 35 years, and he has consulted at the nearby Zuid-Afrikaans hospital. He's also purchased expensive equipment to facilitate his work. He's an active member of the community, and he has no desire to move. Anya Haynes, whose affidavit appears at page 153 of the record, is a physiotherapist specializing in pediatric neurology. She has lived in the greater Cape Town area all her life. She's the co-owner of a health establishment where she provides services. And over nearly 20 years, she has built a referral network and a client base. Her husband works in the area, her children attend school there, and she's a flautist in 3 orchestras in Cape Town. She has no intention of locating anywhere. As this court deliberates on whether to confirm the declaration of constitutional invalidity of sections 36 to 40 of the National Health Act, in paragraph 1 of the Gauteng High Court order, which we find at record page 888, it is these individuals that the court will keep in its mind's eye, together with the hundreds and thousands of healthcare providers and healthcare personnel, present and prospective, like them. Doctors, nurses, physiotherapists, dietitians, occupational therapists, phlebotomists, dentists, carers. Individuals whose calling as healthcare practitioners make them no less entitled than any other citizen of this country to choose where they want to live and work and make choices as economic actors on where they might earn a living or how they might want to invest their resources. The court, we submit, will keep them in mind because the reality is this: on pain of criminal consequence provided for in section 40 of the Health Act, no person may A. establish, construct, modify or acquire a health establishment or a health agency. C. provide prescribed health services, or D. continue to operate a health establishment or health agency after the expiration of 24 months from the date this Act took effect without being in possession of a certificate of need. Considering only subsections A and D, no health agency and no health establishment will be allowed to operate without such a certificate. The scope is broad. In accordance with the definitions in Section 1 of the Health Act, which we quote in full in footnotes 5 and 6 of our heads, those are the definitions of health agency and health establishment. This includes hospitals, medical practices, physiotherapy centres, dental rooms, nursing homes, rehabilitation centres, clinics. Unlike the holders of mineral rights some years ago, existing establishments will not be able to simply convert their old order rights and be protected from deprivation. No. In the hands of the Director General will lie the ability to refuse them the opportunity to keep open their practices. But there's more. No person will be entitled to provide prescribed health services without such a certificate, as Section 36(1)(c) tells us. The respondents see this as a virtue, because they say, well, not everyone that is rendering a health service will actually require a certificate of need, only those who render services that are yet to be prescribed by regulation. In paragraph 38 of the written submissions that they made on 4 September, they explain that it is, quote, only once regulations are made that one will know which healthcare services are prescribed for purposes of Section 36(1)(c). But that's not a virtue, nor a consideration that can save this scheme from constitutional invalidity. Quite the contrary. As the court below correctly held at paragraph 39 at page 903 of the record, it bears mentioning that there is no definition of prescribed health services, and so the con scheme may operate as widely or as narrowly as regulations, which have not yet been conceived, may determine. That means that the extent of the operation of the scheme is vague. Indeed, as the Director General said before the High Court in the answering affidavit at paragraph 16 at page 441 of the record, it is extremely difficult to assess how the con scheme will function in the absence of regulations. This court will appreciate that since regulations cannot be relied on to interpret the legislation or to save it from constitutional invalidity, the Director implicitly accepts that the scheme is vague and therefore unconstitutional. Moreover, nothing in the Health Act constrains the Minister in deciding what health services might or might not be subject to a certificate of need. The respondents themselves point out in paragraph 110 of the answer in the High Court at record page 474 that Section 90 of the Health Act, which circumscribes the powers of the Minister to make regulation, doesn't deal with the power to make regulation related to health services. We say what the Minister is given is an untrammeled lawmaking power to decide which health services will be subject to the scheme and which not. And whatever the extent of those prescribed health services might be, those to be rendered by individuals, what the respondents cannot say, as they did before the High Court, is that the only persons who could conceivably be subject to the scheme are those seeking to establish, construct, modify, or acquire a health establishment or agency. They said that at paragraph 111 at record page 475. They also can't say that the scheme applies at a health establishment or health agency level only, and therefore that practitioners can rely on a health agency or a health establishment's certificate. But they said that in paragraph 116 of their answer at record page 476. It's plainly not what the Act provides. And in any event, every doctor, every physiotherapist, every dentist who has rooms of their own operates a health establishment within the meaning. The list goes on. The individual impact cannot be avoided. And what cannot also be ignored is that if the health establishment or the agency does not obtain a certificate, those employed by it will be left without employment, unless and until they can find employment with another agency or another establishment, assuming that they have staff requirements. But remember, there's now a rationalization of the services, so where are they going to find their employment? It's cold comfort to those employees that the Director General said in paragraph 100 of the answer before the High Court at page 472 that the certificate attaches or is linked to health agencies and not to healthcare personnel. Cold comfort. The impact is individual, no matter how narrowly the respondents seek to interpret the Act. Dr. van Heerden will not be able to keep open the practice at her home, and nor will Dr. Spies, unless they obtain their certificates. The health agency that employs Gracious and Patricia will have to close its doors if it doesn't obtain the certificate. And these two women and their fellow employees might have to go looking for work elsewhere. Johan and Sholwe, the freshly qualified graduates, they will also have to obtain a certificate of need if they want to open their rooms upon finishing their studies. So, how will the Director General decide whether to issue or renew a certificate? Well, section 36(3) says he must consider 13 factors. Not one of those factors that the Director General must consider in the Act includes the applicant's position, goals, ambitions. The applicants as agency, their capacity to make meaningful choices about their own lives does not seem to warrant consideration under the scheme. Nor apparently will it be relevant that a healthcare provider or a prospective healthcare provider has ties with the community, has built a reputation, or maintains relationships with the people they serve. As the court below held at paragraph 40 in the record at page 904, it is what is not set out as a requirement for the DG to take account of which is problematic. He also said, the learned judge did, at paragraph 42 at page 904, the scheme is silent on the extant rights of both the owners of private health establishments, private healthcare service providers, and private healthcare workers. Such extant rights include their integration and professional reputations within the communities they currently serve, along with the significant financial investments and commitments made by them to deliver the services they provide. Of course, what must be considered in terms of section 36(3) is extremely wide. It gives the Director General immense powers. How will the Director General or the Minister on Appeal decide what is an equitable distribution of health services and healthcare resources? What is an appropriate mix of public and private healthcare services? We submit the mandatory considerations in section 36(3) are broad and vague, rendering them functionally meaningless and granting the Director General and the Minister significant leeway in their interpretation and implementation. It amounts, we say, to the impermissible grant of broad discretionary powers that contain no internal constraints, as this court described in Daywood, which we quote at footnote 35 of our heads. Why, one might ask, should a scheme so intrusive upon the rights of healthcare practitioners pass constitutional muster? In the answering affidavit before the High Court, at record page 446, paragraph 26.4, the respondents referred to a white paper, and that white paper we find at volume 8 and particularly 696. It talked of licenses aiming at correcting historical inequities. In paragraph 28 of the affidavit, also on page 446, again referencing the white paper, but this time at 697, they spoke of the need for licensing of practices on the basis of a certificate of need on a geographical basis to promote equitable distribution of our limited resources. In line of that, with that intention, the Director General, before issuing or renewing a certificate of need, must, in terms of section 36(3)(b), consider, quote, the need to promote an equitable distribution and rationalization of health services and healthcare resources, and the need to correct inequities based on racial, gender, economic, and geographical factors. In the submissions of 4 September at paragraph 24, it is said that the requirement of the certificate is critical to the regulation of health services in South Africa in the public interest because, quote, it empowers the Minister of Health to ensure more equitable coverage of health services rather than an over-concentration of health services designed to cater to the few who can afford it. And that's also consistent with the position in the answer at page 475 that geographic distribution is the main aim of the scheme. In paragraph 24 of the submissions once more, the argument is advanced that the scheme intends to regulate all health establishments, not only hospitals, including public and private, to optimize resources and promote the spirit of cooperation and shared responsibility among public and private health professionals and providers and other relevant sectors within the context of national, provincial, and district health plans. So this is what the respondents say is consistent with section 27 of the Constitution. This duty of the state to make health services progressively available. But the question that this court may legitimately ask is, how will this licensing system achieve that purpose? Because in their answer before the High Court, at paragraph 160, record 489, it was asserted that the minister cannot compel and will not compel any practitioner or personnel to work where they do not wish to work. And at paragraph 164, record page 490, it was alleged that no relocation of healthcare establishments, health agencies, or healthcare practitioners will occur. So on that version, what the scheme envisages is that the Director General can decline a certificate of need, thereby precluding this establishment or agency from operating, preventing that healthcare practitioner from rendering the prescribed health services, however broad or narrow that might be. They may take away the livelihood of the individuals without actually being able to ensure that then those practitioners will go elsewhere and redistribute to another area. All that the respondents can do is to point to a possible connection between the scheme and its intended aim, and this is what they do at paragraph 210 of the answer at page 501 of the record. They say the criteria used in evaluating the issuance of a certificate of need will hopefully incentivize health agencies and establishments to direct their investment in the creation of new infrastructure for underserviced areas. But that hope is not based in a reality. First, the migration of South African healthcare personnel to other countries is a well-known fact. In the record at page 114, line 19, we see that in 2019, the then health minister explained that there was a shortage globally of healthcare practitioners and that it was attractive for those from low and middle income countries to migrate to other countries in search of better living and working conditions. If we make it so difficult for the practitioners here, will they stay? Will they move to the underserviced areas? Or will they go? After all, healthcare practitioners must be taken to be economic actors that will make rational decisions about their ability to earn a living at a different location. And in any event, the great irony is this. In terms of section 36(3) sub J, when the Director General must consider an application for a certificate of need, what he must consider is the probability of the financial sustainability of the health establishment or health agency. So now the applicant who can't work in the big city must apply and show the Director General that the practice in the far-flung area that nobody wanted to go to will be financially stable. And the court will remember the story of Barbara Pretorius. She describes in paragraph 5 of her affidavit at page 138 of the record how, when she first located to Knysna, after 15 years of already being in practice, she had no customer base and no referral network. She doubted whether she could build a practice. There was a time when she considered closing it, and a colleague told her to stick it out for 1,000 days, because it usually takes 2 to 3 years to establish a sustainable practice. How? This court must ask itself, can it be said that the scheme that places these requirements on practitioners undoes the systemic and persisting inequities in the geographic distribution of health establishments and agencies in South Africa? Can this certificate of need scheme address the problem identified at paragraph 36, page 449, that the country has relatively few doctors? Can it address the difference between public and private healthcare expenditure mentioned in paragraph 37, page 449? Is the scheme responsive to the problem identified in paragraph 41, page 455, that there is a dearth of healthcare establishments and healthcare personnel in particular areas? No, no, and no. There simply is no rational connection between the stated purpose of the scheme and the outcomes that can be achieved. It fails the test. It fails the test of Law Society versus Minister of Transport, which we quote at paragraph 70.9.1 of our heads, that there must be a rational nexus between the legislative scheme and the pursuit of a legitimate government purpose. Because that requirement is meant to promote the need for governmental action to relate to a defensible vision of the public good and to enhance coherence and integrity of legislative measures. I can't describe it any better than the court below did in paragraph 63, page 911. The power to withhold the issue of a certificate or the renewal of a certificate is nothing more than a blunt instrument which would be used by the DG to reduce the number of healthcare establishments and private healthcare providers who could lawfully provide medical care within a particular area, in the hope that being deprived of their property and ability to earn a living, they would, without more, accept the losses foisted upon them and relocate to an area in respect of which the DG had determined a certificate would be issued. The learned judge in that same paragraph went on to say, even if this did occur, there would be no certainty. The sword of Damocles hangs over every private healthcare establishment and private healthcare provider in perpetuity for so long as they are required to renew a certificate of need. Because indeed, even if a certificate is issued or it is renewed, it's not the end of the matter. The statute in section 37 simply provides that a certificate of need must be valid for a prescribed period that may not exceed 20 years. So the minister, acting in terms of section 90 of the National Health Act, may prescribe a period of 1 year, 2 years, 3 years, 5 years, whatever of period of validity he deems fit, so long as it doesn't exceed 20 years. So simply put, through regulation, he can set the validity period and decide how soon another application must be made. And to illustrate how this might be applied, this court may have a look at the draft regulations that the minister published in June 2021. In Regulation 4 of those draft regulations, what the minister provided is that a certificate of need issued to existing health establishments and health agencies shall be valid for a period of 3 years from the date of issue. That appears at record page 81. 3 years, because the minister decides so. I'm not saying these regulations should be used to interpret. What I am saying is it shows how the power can be exercised completely arbitrarily. With that in mind, how can it be asserted that the scheme will improve access to healthcare services? Even if the DG issued them a certificate in respect of their existing facilities, valid for a period of 2 or 3 years, why would Barbara Pretorius or Dr. Brian Spies invest in extensive equipment, faced with the uncertainty of a fresh application in 3 years? There's more, because arguably the most burdensome aspect of the Certificate of Need scheme is that the DG is granted the authority to impose conditions on a certificate. He can impose any condition regarding the nature, type, or quantum of services to be provided by the health establishment and the health agencies that are lucky enough to be issued by a certificate. Any condition on the manner in which human resources are to be deployed at the facility, how diagnostic equipment is to be used and shared, and they may even compel private establishments to conclude partnerships agreement with the public. And of course, the Certificate of Need may be withdrawn if, inter alia, in the assessment of the Director General, the healthcare provider or the healthcare worker, quote, obstructs the state in fulfilling its obligations to progressively realize the constitutional right of access to healthcare, according to section 36(6)(d). One asks oneself, how can a healthcare provider do that? Frustrate and obstruct the state? By not conceding to being indentured to the state to provide healthcare services that the state isn't providing? At paragraph 153, page 487 of the record, the DG and the Minister defend their position on all of the intrusions of rights through the grant of these powers on the basis that health is a service that the government must provide to all citizens equally. What appears to escape them is that it is the government that is clothed with that burden, not private practitioners, who can be pawns just distributed by the state at its will. What all of this shows us is that on its face, the Certificate of Need scheme intrudes upon the rights of healthcare practitioners and health workers because the DG and the Minister are quite simply not sufficiently constrained in dealing with the various aspects of the scheme to protect the rights and the interests of the affected individuals whose livelihoods are made subject to the scheme. And so in the circumstances before this court, as we did before the High Court, and for all of the reasons traversed in our written submissions, we say sections 36 to 40 violate the separation of powers, are irrational, are impermissibly vague, and they unjustifiably infringe constitutional rights. We contend that the scheme on its face is unconstitutional. It's evident from an examination of the text itself. It's not, as the respondents would have it in paragraph 131 of their answer at page 480, that my clients have described the provisions in the most extreme of terms. Rather, it is that the scheme as it is set out in the Act produces these extreme effects. It's not for the respondents to say that the scheme ought not to be declared unconstitutional just yet, because regulations will save it in due course. They must accept the consequences of what they said in paragraphs 18 to 19 of their answer in the record at 442, that without regulation, the scheme is inchoate. It's not for them to argue that the scheme won't be applied unconstitutionally, because the assurances of the current administration that they will exercise their powers cautiously to save the provisions from unconstitutionality is of no assistance. We discuss this fully in section D of our heads, starting at page 16. What is incumbent on the respondents is to show why, despite the obvious problems with the scheme, it passes constitutional muster. Because in EFF versus Minister of Correctional Service, it was plainly explained that no matter how good the objective is, there must be a juxtaposition with the rights of the people that are affected, those whose rights are being infringed. Because it is the state that infringes, and it is the state that must then explain why it should be allowed to limit. The consequence, unfortunately within the time, those are my submissions.
Thank you very much, Ms. Engelbrecht. At the commencement of your argument, you tell us about the current circumstances of some of the applicants. But suppose what you were seeking to demonstrate is what the fears are of what the requirement of a certificate of need will bring. Am I correct?
Deputy Chief Justice, in part, but it's not just about fears. It's about realities for these practitioners.
Okay.
Because the fact is they are being subjected. They are currently in practice. And if these sections come into effect, they will have to, we know, within 24 months, apply for their certificate of need. And in other words, what happens then is they are subjected to this approval system. So the Act affects them. It's not a fear, it's a reality.
Well, I think you've covered some of the ground I wanted to cover in what I want to ask you. The respondents say all that is speculative. It's you arguing in the abstract. You say this is what will happen. And you have no basis to say what you're saying. And they rely on I think the Savoy and Lawyers for Human Rights cases to say, you asking these courts to speculate as to the future.
Yes. May I?
So that's why I'm asking you that question. I mean, what's your response to that?
Yes. My response is through the submissions that have been made about how this scheme will operate. In other words, the powers of the minister and the DJ, they're in the Act. That's not speculative. What will have to be done, which is an application for a certificate of need, that is not speculative. That it is possible not to obtain a certificate of need is not speculative. It is there in the Act. That a certificate of need may be withdrawn. It's not speculative. It's there in the Act. We say all of the submissions that we make show that the challenge is anything but abstract and speculative. It's not a case of the law possibly operating unconstitutionally under some conceivable set of circumstances. It is a law that gives the minister and the DG an extensive set of powers. Powers that infringe upon the rights of individuals in aid of an objective that the scheme cannot fulfill. They can impose the conditions on the services to be rendered. It's there in the Act. They can subject the practitioners to the sharing of their technology. It's there in the Act. There is no provision for compensation in the Act. They can withdraw the entitlement, as I've already mentioned, because there is this broad notion of obstructing the state somehow in rendering its services. And I need to make a second point. These are Section 172 proceedings. And this court, in Lawyers for Human Rights, at paragraph 24, explained it very well. It's incumbent upon the court now to grapple with these issues, because there is already a High Court decision declaring these sections unconstitutional. The court can't now say, well, it's premature, it is speculative. There is a declaration of constitutional invalidity, and therefore the court must enter upon the debate of the merits of the provisions. That's at Lawyers for Human Rights at paragraph 24.
Well, let me ask you a different question. In your written submissions, you don't dispute that the current context in South Africa is that many South Africans still have no access to quality, affordable, and timeous health care. Is that correct?
That is indeed correct.
And the respondents mentioned this as the overarching objective of these provisions that are under constitutional attack. Is that a misplaced reliance on that context?
We submit it is a misplaced line. First, because as I indicated in my argument, there is nothing to suggest that in fact there will be a redistribution of services to poorer areas if certificates of need are not granted in the so-called oversubscribed areas. That's the first problem. The second problem is we know from the judgments of this court that when one looks at a scheme that is, let's call it an affirmative action scheme, a scheme that is intended to improve equality rights, it has to be a plan. It has to be rooted in reality. That came out, for example, in the consideration of this court in the matter of Department of Correctional Services, where my client were also in that matter. We take account of realities, where people are, how they live. We don't just distribute people as pawns of the state because there is a legitimate government objective. That which is done must be rationally connected to the government objective. And if on their own version, as I've indicated to this court, they're not going to force people to move, then how are they going to achieve this? How are they going to improve access to health services? What they are saying is they're going to rationalize in the big cities, but they don't know other than to hope people will move elsewhere.
Thank you.
Thank you, DCJ. Still on this question, in Savoy, it stated that it was held that where there's an abstract challenge, the applicant has a heavier burden.
Yes.
Now, one of the issues that has been raised by the respondent is that the operative term is the prescribed health services. And we know that the regulations are not yet in place and that term is not defined. Now, how do we determine? Because they are saying only those who actually fall in within that term will be required to apply for a certificate of service. And at the moment, you are basically applying for everyone.
Yes.
And you don't know whether some of the medical practitioners may not be required they may not fit in within this terminology. What do you say to that? So in a way, you've decided to come in when you should have waited for the regulations. Then you know exactly who is going to be affected by these provisions.
Yes. May I offer two responses to that question? First, the first problem is that because prescribed healthcare services leaves it to the minister to decide what is in and out, it renders the scheme in that respect vague. When they say that we don't even know what will be covered, we know that the scheme is inchoate without regulations, and so it depends on their version, on the minister legislating what healthcare services will be covered and which not. So that's on their version of the argument. But the problem, and that's the second point, the problem is they jump through hoops to only focus on the prescribed healthcare services aspect. But what they ignore is sections, the sub-definitions A, so 36(1)A, and D. A and D apply without regulation, without prescription, to health agencies and health establishment. In the case of D, it applies to all existing health establishments and existing health agencies. So it's not a question of regulation for them. It's only in respect of the prescribed healthcare services. And what they then say is, and that's the argument I dealt with earlier, well, it actually doesn't have an effect on individuals. But that's to overlook that health establishments include a doctor's room. The doctor that has the rooms at the home, Dr. Spies, that filed an affidavit, who's one of the applicants here, he's practiced from his home in what is defined as a health establishment because he renders for-profit health services at his home in a converted space there. He won't be able to do that without the certificate of need. And that's why we say the impact is already there definitely on A and D. It is also there on C because the minister has untrammeled powers to decide what is prescribed and what is not.
Certificate of need, I take it that the person who will determine that there is a need here would be the DG.
Yes.
And not the applicants, the medical practitioners.
That is correct. So one conceives of the applicants making application and having to explain why there is a need. We know from the various subsections of Section 36 that there will be a variety of considerations that will be taken into account. It's not just need. It's also, for example, human resource considerations. It is a consideration, if I may. I just briefly want to open the Act. But there are a variety of matters that will be taken into account. Need will be one of them. But I was discussing with my junior, sorry, I forgot to mention him when I introduced myself, Mr. Darfel. When I was discussing with him earlier, I said to him, well, I wonder how it will work. So at the moment, there are, say, 10 doctors in a particular area, and they must all make application for a certificate of need. So is there a hierarchy? The ones that have been there for the longest? Because suddenly the Director General, we don't know on what basis, but will determine there's now too many doctors. What is too many, we don't know. But he determines there are too many, there can now only be 8. Which 2 are out? We simply don't know. It's left to the Director General to make these choices.
In terms of the provisions as they stand,
Yes.
even those that are existing now who are operational, if the provisions stand 2 years after the coming into effect of the provisions, they will have to make an application for the certificate of need.
In fact, as I understand it, they would have to make application before, because when the 24 months pass, so upon the Act coming into effect, 24 months after that, they will have to have a certificate of need. And knowing the bureaucracy, I would, if I were them, have to apply earlier rather than later. So the application would have to be made straight away, I would imagine, in order to allow them to be in possession of the certificate within 24 months.
How is the situation different from where people apply for mining licenses and casino licenses? Is there a difference between the two? Can one distinguish the two, especially when you are talking about the 20-year period that has to be taken into account?
Well, I suppose the first big difference with a mining license is that is where the state is the custodian of the mineral resources. And so the state grants an indulgence, as it were, to those who exploit the mineral rights. And it says you can come for a period to exploit these mineral rights. In the case of health practitioners, these
casinos which are owned by private entities.
Pardon? The casinos, yes. I must say, I find it hard to find an analogy between somebody who answers a calling to give healthcare services to somebody who is, well, firstly a business, because it will typically not be an individual.
I'm trying to maybe establish whether there is any distinction, because there's this 20-year period where they say the certificate of need will be valid for 20 years or something like that.
Yes.
Whether one would then have an argument to say, well, you can't equate this to that. That's what I want to know.
I say again two things about that. Firstly, the maximum period is 20 years in the Act. It's not 20 years, it's a maximum of 20 years. As I've already indicated in draft regulations for existing health establishment, the proposal is that it will be 3 years. So one can't just look at the 20 years. In this case, when we look at the 20 years and the fact that it's up to 20 years, we must bring into account the section gives immense power to the minister to regulate that duration. So that, we say, is problematic. But we say also that the provision of health services by a doctor is connected to the person. It is not somebody who applied for a license as a business. It's not a business. It's not a business that applies to have a casino. It's not a business that's applying to mine. It's an individual who wants to live and reside and render their health services there. So we say that to equate the licenses for casinos and mines with these licenses would be wrong.
Thank you, TCJ.
Thank you. Ms. Engelbrecht.
Just a quick cheeky.
During your submissions, you said that the DG admits that without the regulations, it will be difficult to state or to respond to your complaints about the CON system.
Not quite that, but what they say is it would be difficult to conceive of how the statute would operate in practice. So it's slightly different, but I understand what you are putting to me.
Okay. The regulations, I'm reading in section 39(1), which seems to say that the minister has a discretion to make the regulations because it uses may there. Do you understand it that way?
Yes. The High Court, in fact, made the same observation, and we also make the submission. It says the minister may, after consultation with the National Health Council, make the regulations. But as I stand here before this court, I must accept that in 2014, former President Zuma did seek to bring these sections into operation. And then he realized that there were no regulations that were passed, and for that reason thought that it would be impossible, because if you can't make application, if there's no procedure for making application, how can you, in terms of Section 40, make it a criminal offence not to have the certificate? So I will say this, I'm not entirely sure that it is a discretion. It does seem as if regulations would have to be passed to at least explain what the process is that would have to be followed to make application.
Perhaps I should reserve that for Mr. Maineche.
Perhaps.
Yes, because I'm interested. If Mr. Maineche's submission is that it will be clear, the scope of their functions at least will be clear, and they will be able to clarify them when there's regulations. And I'm worried that if the making of regulations is discretionary, and I know that we don't have regulations now at this point, I'm worried whether we, in fact, waiting for regulations that may or may not come would be a reality. We'll be taking into account the reality.
I don't want to speak on behalf of my learned friend, Mr. Maineche, but I suspect he is going to say to you, Justice, that there will be regulations coming, and that is certainly the intention that we see from the June 2021 draft regulations that have been produced. But we say that that is actually not the real question, because the statute has to stand on its own 2 feet. In the same way that the respondents criticize my clients and say, well, you have to look at this statute and look at it objectively. You must look at the words in context and purposefully. You can't reach for other evidence to come and interpret the statute. By the same token, the respondents can't do that. If they cannot defend the constitutionality of these sections on the words as they stand, it is no assistance to them
Is
not.
there no merit to them saying that, look, what we're empowered by the statute is to regulate the health sector, and you are criticizing and making speculation about what will happen and what will not happen. Let's wait for the regulations to come into effect, and then we can then answer you and say that this is how we're going to regulate it. Your own idea about how we're going to regulate it is different from how we've been given, or on the powers of how we have been given to regulate the industry.
Number one, regulations can change. The current administration may be magnanimous. They may issue regulations.
It's just gone 11 o'clock Central African time on this Tuesday, the 9th of September. We've been listening to the litigation that's unfolding in the Constitutional Court, where Trade Union Solidarity and others have mounted a challenge against prescripts of the National Health Act. In the main, they're pushing back against this need for a certificate of need, which they say violates the separation of powers and is irrational. Making arguments on their behalf on your screen is advocate Margrethe Engelbrecht RC, who is now facing questions from the justices who are, I suppose, in some ways going through her arguments with a fine-tooth comb. Coming up, we expect to hear from the state. We know that respondents in this case are the President, the Health Minister, and the Director General. Let's continue listening in.
Of need subject to any condition, for instance, regarding public-private partnerships and all of that. It's not clear to me what the Director General is empowered to do there, because to say any conditions is very vague.
Well, precisely, Justice Chikri. It is vague, and it gives broad powers. And that is problematic. It is significantly problematic, especially in light of the fact that we can't see how the exercise of these powers that infringe upon the rights of these individuals, how that actually leads to a legitimate government objective being met. It's significantly problematic. It's vague, and it gives them broad and sweeping powers.
Thanks, Ms. President.
Ms. Engelbrecht, can you point to an infringement in the current wording of the Act? Or will the infringement become operative or clear once the regulations are passed?
It can potentially operate at two levels. It might be that the content of the regulations may make it even worse. But at the moment, the focus of the attack is the extent of the powers that's been given to the Director General first, but then at a secondary level to the Minister. So, in other words...
Elaborate on those powers.
If I can elaborate on that.
Please.
Well, the fact that the Minister is entitled to, as it were, arbitrarily decide what the period of validity will be, up to 20 years, but otherwise no restriction. That means that there is an infringement. The fact that the Director General can impose conditions, and those conditions are
Where do we find that in the current legislation?
if I can just, it's 36.5, page 56 of the record, this appears. So in subparagraph 5, the Director General may issue or renew a certificate of need subject to, first there's compliance with operational norms and standards, And then second, any condition regarding the nature, type, or quantum of services to be provided by the health establishment or the health agency. So in other words, the power of the Director General is to tell a health practitioner what services it must render and how much of it. I'm not entirely sure how that operates, but so instead of complying with their duties as health practitioners, keeping to the oath and rendering those services that the patients require, they will be subject to this intrusive regulation by the Director General telling them what services and how much of it they are allowed to give. The second one, human resources, any condition regarding human resources and diagnostic and therapeutic equipment and the deployment of human resources or the use of such equipment. What may you have in your practice in order to service the needs of your client? Your human resources, what must they look like? How you must share them with others potentially. Public-private partnerships. That is a condition that may be imposed. So whether or not you want to enter into a public-private partnership will not be your choice. It will be a condition that the Director General will be capable of imposing. Types of training to be provided by the health establishment as a condition. So the private health establishment can be told, you can get your certificate, but you will have to train people. Whether or not you have the resources, who knows? So, and then there's any criterion contemplated in subsection 3. So then we go back to subsection 3, which is all of these matters of, that are listed there in A to M. So when...
At what we've dealt with in sub 5 and the conditions. The conditions that we've gone through in 1, 2, 3, 4, and 5, are those conditions to regulating the industry, or are those conditions related to what they say is the purpose of this act, to increase access to health care?
It's not entirely clear, because it might be that the nature, type, or quantum of services to be provided might relate to the purpose. But it's not clear to me how that can be, because if the idea is to make healthcare more accessible, why does the Director General need a power that enables him to limit the quantum of services that is being rendered by a particular healthcare practitioner?
Let's perhaps look at this at a sector closer to home, the Legal Practice Council, for example. What is the function of the Legal Practice Council? What type of regulatory body is it, and how does it regulate practice of law in the profession?
Well, it regulates at various levels. It starts with the admission by court, but only with the assistance of the Legal Practice Council confirming that the necessary requirements have been met. And then, of course, there is payment of a fee to it as a regulatory body, and it has certain standards that are then imposed. There are disciplinary powers, for example, when that is not complied with. If I may add, all of that exists for the health profession already. The Health Professions Council does that. There is oversight of the professional duties. This certificate of need is not concerned with that sort of regulation of the, as it were, the quality of the services, or making sure that people are complying with their ethical duties, like, for example, the LPC might.
This is not merely regulation of the profession,
Yes.
controlling the standards. It's going further.
In fact, it is decidedly not controlling standards, Because we've got the different statutes, for example, the Allied Health Professions Act, and under these various statutes, there's regulation of professional standards in the way that the LPC would do. Then there is also in the National Health Act, Chapter 3, and that enables the department to set certain norms and standards about what facilities must look like and what quality they may have. So there is already in place all of what is needed to ensure that the quality of the services is rendered at an acceptable level and that it's rendered in accordance with professional duties. This is not that. This is, as it suggests and as is conceded, an aim to say, we will decide whether or not there are enough of you here, and if there are enough, we hope you'll move elsewhere because you won't get a certificate of need here. It's not about standards, although that is a case the respondents make, but that's provided for elsewhere. Yes.
Also know that we have challenges with access for justice. Would it be possible to introduce an act like this in respect of attorneys and advocates? How could it be done? In what manner would it be able to be done?
Well, I would suggest there would be far more applicants before this court than there are today, because I don't think the lawyers would take that. But that is exactly the point. Because what is it that we do as legal practitioners? Yes, there is access to justice rights, and there are ways of dealing with that. For example, that we must render pro bono services. Now, under the Legal Sector Charter, we assume certain obligations in order to train people and to promote access to justice. We can have, under the LPC, community service obligations. All of that can be done to assist in promoting access to justice. But the suggestion that we say, well, you are senior counsel in Johannesburg, there are too many of you, we need somebody in Kuruman to be senior counsel. So you can apply there. It would be inconceivable. It would be inconceivable in submission. You don't fix the problem of access to justice by moving around the people who render the services.
At Irrationality, does the first to seventh applicants concede that there is a nexus between the purpose of addressing the disparity in access to healthcare with the requirements or the contents of Section 36? And let me put the second question. If there is a nexus, is the test for rationality not met?
Well, in submission, there isn't a nexus. Because it is not good enough. That's what EFF says. It's not good enough to just say, I want to promote a very important public good by these provisions. What must be done and what must be shown is that my intention to promote this public good will be served by the measure that I have proposed. And then, of course, when we say it's not possible to improve the quantum of healthcare services in far-flung areas through this scheme, then the main objective cannot be met. And if the main objective cannot be met, then the scheme in its entire conception is irrational.
What does the respondent say to the applicant's assertion that these measures in Section 36 is not going to prove access to healthcare?
Well, maybe I will leave it to Mr. NHA to answer that question, but I did indicate to the court earlier that they, in explaining...
Do you understand the respondents to be saying?
Well,
in answer to that question.
What they say is they hope hopefully, and I quoted that earlier, I gave the reference to the court, they say that hopefully, taking into account what the requirements to obtain a certificate of need are, hopefully people will apply to go to the far-flung areas. That is the answer.
Is that not enough to meet the rationality test?
No. In submission, no. In order to upset an entire structure of how the healthcare professions work on the mere hope is not good enough, number one. And number two, if there is to be a hope, it must at least be grounded in reality. And the reality, as I indicated earlier in my address, is that once it becomes onerous to practice either where you are, or onerous in the sense that there is an expectation that you must move elsewhere, now the opportunities open up. And now the healthcare practitioner might legitimately say, if I have to go to Kuruman and that's not where I want to be, I might also not want to be in some far-flung place in Canada, but I'll start considering that. And then what happens is through regulation, through excessive regulation of healthcare practitioners that we can ill afford to disincentivize them to either study the health professions or practice in the health professions.
Thank you, Ms. Engelbrecht. You introduced your argument by sort of taking us into the hearts and minds of a few healthcare professionals. And I suppose this case is fundamentally important, not just for healthcare, but in a sense for transformation in South Africa. And whatever the outcome might be, there must be some fundamental questions that we need to confront, and we may need to confront them in this case. And let me start with that I suppose one would see the importance of this case depending on one's vantage point. You've given us the vantage point of the first 7 applicants. But imagine someone living in the village of Khapasha deep in Skokuni may also be looking at this case with hope and expectation that their lives will change through the provision of healthcare services. And I think you don't take issue with that. However, you do say in your written submissions that this case is not about access to healthcare, Section 27.3. You say it's not about whether it's legitimate public objective, etc., and it's not about denying the grave injustice that millions of people face. You say it's not about that. And in your oral submissions, you say that the responsibility of the state under Section 27, subsection 3, is not one that must be foisted on private healthcare practitioners. So I want to ask you, as a matter of principle, do you say that in a society such as ours, where there might be a skewed distribution of healthcare services, and many academics have written about this, Professor Alex van den Heever speaks about the growth of the private hospital industry and sometimes the incentive to overservice. And public hospitals may not have, there'll certainly be no incentive to overservice. I'm not suggesting that that's par for the course. I'm just saying that there are those discussions. So under those circumstances, when there is a pool of resources and there's a massive need across the country, are you saying that individual rights, the ones that you rely on, the right to your profession, etc., freedom of movement, etc., will always trump, as it were, the transformative objectives? And my direct question is, can a certificate of need ever be found to be unobjectionable if it has that objection of moving resources?
If a certificate of need had the capacity to achieve transformation in the way envisaged, then of course it would have to be weighed. There is the justification exercise. In other words, we will look at the infringement of the rights, we will look at the reason for the infringement, and there will be a justification analysis done. But in that justification analysis, because it is state that has to, for example, in this case, promote healthcare, and in aid of performing its duty to promote greater access to healthcare, wants to infringe on the rights of individuals, it would have to bear the burden of showing that the way in which it has chosen to do this doesn't go beyond that which is justifiable, and that there is not another less intrusive means to achieve this same purpose. So it's not a question of never trumping, but it is a question of an appropriate balance that has to be struck. And when that balance is struck, it has to be that there is a proportionality between the infringement and then ultimately the outcome that is achieved.
Thank you. Talking about the justification analysis, is it your understanding that when the High Court embarked on its justification analysis, it really posited these individual rights against the nature of the intrusion and reached the conclusion that the limitation was not justified? I'm not sure if I read it correctly, but I didn't get a sense that the High Court sort of posited individual rights with broader community rights, which is also part of our jurisprudence, because sometimes we deal with limitations and we have to look at whether the limitation is reasonable and justifiable in open and democratic society. But sometimes rights compete with each other. And this court had to deal with that in numerous cases where, and it still happens within a framework of a limitation, but it's really a competition. Maybe that's the wrong word. But where rights come into, where individual rights and communal rights might. And this court has said there's no magic formula. One must go back to the Constitution, you look at your limitations, and you find the balance, as it were. And so that's really the difficult issue I want to explore with you, whether under any circumstances it will always be individual choice as to where I want to practice and how I want to practice that ultimately will carry the day. Because if that is where we ultimately go, then that is where the society will ultimately stay.
If I may,
it may be an unfair question, but it's one that's at the heart of this application.
I understand that. The issue that we made and the point that also the court below made is that the difficulty with that section 36.3 analysis is that it is entirely, as it were, government-centric. And let's read government-centric then for the interests of the community. What it doesn't do in any way, in any of those provisions, is to at least also bring into account the rights, the aspirations of the individuals. Okay. So what we say is the section in and of itself doesn't provide for the balancing. It only looks at the one side. So if our criticism is we only look at one side, well, that's also a criticism of the legislation. Of the legislation itself.
Good. And then just lastly, getting to section 36.3, you raised your concerns about the vagueness. You would accept even the best drafters have their legislation scrutinized on a daily basis, because that's human nature. Depending on our vantage point, we seek to give different meaning to words. And courts are called upon to interpret them, and over the course of time, what may be vague gels into, and if we look at all the sort of legislative history in our democracy, this court is often called upon to interpret an individual word, and that's par for the course, if I could. And so I have two questions really that over time, certainly 36 will, in a sense, develop its own coherence. And if there's a vagueness, is it of the kind that would render it at this stage unconstitutional, or is it of the kind that may be associated with in a sense, the interpretive exercise that we invariably engage in. And my second question is that, would you accept that a decision of the DG under 36 would be subject to review under PAJA? Because
Well, to answer those two questions together,
okay.
it is quite interesting because instinctively the answer would be this is an administrative decision and therefore it would be subject to review under PAJA. But what the respondents say at various points in their answering affidavit is this decision that the Director General will have to make is a polycentric decision. And it bothers me. It bothers me because I am foreseeing into the future that when that decision is sought to be reviewed, that will be the answer. It was a polycentric decision and therefore not subject to the standard review under PAJA.
Yeah, but Ms. Emre, it's not really what they say about it, isn't it?
Yes.
PAJA is a definition that if it's external action that it adversely impacts on the rights of somebody, and from your initial description, it would fit neatly into PAJA. And it would be for a court to make that determination whether PAJA is applicable. And the simple point I wish to make is that if PAJA is indeed applicable, which I think it is, then PAJA provides for an additional layer of safeguards, as it were, with regard to ensuring that the administrative action that the Director General takes under Section 36 is subject to the pretty tight regime of both PAJA, but also in terms of how legality review has advanced in our courts over time. So in a sense, in that way, there is a framework, but as you point out, we're looking into the crystal ball.
But it's not just looking into a crystal ball. Justice Colopin, you point out that over time there might be interpretation and guidance given. But in the meantime, the power of the minister, well, first of the DG and then of the Minister on Appeal, is to make these decisions and to afford its own interpretation. So what we are saying is, well, in due course they might develop an interpretation that would trammel the powers of the Minister and the DG, and therefore we can over time make the statute constitutional. In submission, that is not the appropriate way. It's not for these individual applicants to have to go and apply, be knocked back. Who knows how long these decisions will take, because we know what happens in other applications, for example, for mining rights and the like. Make the application, get knocked back, go to the Minister, wait for however long he decides to take on the appeal, because despite the prescripts about how long appeals must take, it doesn't happen in that time period. And then go to a court on review, and Deputy Chief Justice Mlambo, I think, is maybe most acutely aware of all here, how long it might take to ultimately have that review heard. And so 3, 4, 5 years down the line, what has that practitioner, that health practitioner, been able to do? Not increase access to healthcare services. We can't say that it will be fixed in due course by case applications. If the Act is unconstitutional on its face now, it should be declared so.
No, I accept that. My question was posited on the understanding that if there's an argument that even if it's vague, it's not sufficiently vague to render it unconstitutional, but I think your argument is that on its face, it's unconstitutional. And so just lastly, and I don't want to put words in your mouth, but you suggested that a certificate of need may well be constitutionally acceptable under certain circumstances.
Well,
if that is so, would you describe what those circumstances may be?
Well, I think that's maybe where the difficulty lies. I was answering a hypothetical to say, is there a possibility that some sort of scheme like this might be constitutional? Yes, of course, it is possible. On my feet, thinking about what that would entail, well, it would at least, compared to what we have now, entail that the powers of the Director General and of the Minister are more clearly circumscribed, number one. Number two, that if we are talking about what is an equitable distribution of healthcare services, that be made clear. What equitable is, what the standard is, will have to be made much, much clearer. What will have to be made clear is that there can be no compelling of people to render services where they don't want to, or to share their services if they don't want to. That may carry consequences for them, but they can't be compelled. There are a variety of, it is quite difficult. It's something I actually, I thought as I was preparing for this, because I thought, is there a way that surgery can be done, for example, to these provisions? And I thought, on balance, no, because this scheme, as it is now conceived, is so intertwined, all the different provisions, that starting to do surgery will have unintended consequences. So maybe Parliament must be told to start afresh with some guidance on specifically giving direction to the Minister or giving direction to the Director General. But in our submission, the certificate of need really isn't needed. The certificate of need is not the solution to the problem. And so maybe the government could look to other means of rather truly transforming the healthcare industry, making available services by ways less intrusive on the individual rights.
Yeah, well, that brings us back to the same problem. Because if individuals have free choice as to where they want to practice, where they want to live, then we're stuck there. And maybe that's where we'll be. I'm not sure. Thank you.
Well, if the state is operating on a hope here, as they tell us they are, well, why not give content to that hope, for example, by establishing public health facilities, by incentivizing people with a carrot? In other words, offering the type of salaries for people to go to the far-flung areas, as they do already, for example, in relation to community service and internships, where they give preference and higher income to those who are willing to go to the far-flung areas. They can do that. They can incentivize, but they shouldn't be compelling.
Okay, thank you, Ms. Engelbrecht. Just finally, the entire Constitution and our entire presence here is based on hope, isn't it?
On
hope.
That is true.
Ms. Engelbrecht, Justice Majid still wants to ask you questions, but he'll do so after our tea adjournment. We're going to be adjourning for 20 minutes. Thank you.
As it pleases you.
All right, so there you have it. These are live visuals. We're beaming to you from the Constitutional Court. We've listened to the first half, if you like, of this litigation, which is centered around the constitutionality of sections 36 to 40 of the National Health Act. The case has been brought forward by Solidarity and others who initially won this case in the High Court in Pretoria. But of course, when it comes to matters of constitutionality, the final call needs to be made by the Constitutional Court, and this is why we are here in a way. We've been listening into arguments, that have been advanced by Margaretha Engelbrecht, arguing on behalf of Solidarity. And just to summarize the thrust of the argument they've made, this is really centered around this certificate of need, which as a health practitioner or agency, you must get from the government before you are able to practice legally. What Solidarity is arguing is that this is arbitrary, number one. The prescripts or the powers of the Minister and the Director General are not clearly outlined, and in fact, part of this piece of legislation violates the separation of powers. In other words, the idea that the executive should not interfere in the work of the judiciary and the work of the legislature. Government has pushed back on this on multiple fronts. They say the certificate of need is necessary for a whole host of reasons, including ensuring that there is quality services that are being prescribed, and in fact also to ensure that there is some kind of restorative justice, especially for far-flung areas that otherwise would not have an opportunity to have access to these healthcare services. I don't want to speak on behalf of the President, the Health Minister and the DG, who are the respondents in this case. I'm sure their lawyer will be a whole lot more articulate on the other side of this tea break, but that's where we are so far. Solidarity really hashing out why they say that this scheme, the Certificate of Need, is in fact irrational and should be essentially scratched out. They say it's arbitrary, it violates the separation of powers, and in fact adds a barrier of entry for healthcare practitioners who should be given the right to practice where they want, in the ways in which they want, as long as, of course, this is all within the confines of the law. It's fascinating. It's legal jurisprudence in the making. And of course, the outcome from the ConCourt will have far-reaching implications, I think, no matter how it swings. That's why we'll be watching that story very closely for you.